Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How you guys doing today? How we doing? I hope you're doing well. The Schabusiness trial is not over, but the first part of it is due to a weird artifact of Wisconsin law. What was happening there? Weird artifact. Well, I don't know if it's a weird artifact of Wisconsin law due to something that I have not personally seen. Not that that means much, honestly, but they're doing this trial in 2 phases. We're going to talk about it. We'll talk about the verdict. I've got a little bit of discussion on how the trial went, things I like, things I don't like, things that really annoy me and anger me. Some discussion about the specific law that she's charged under and my problems with generally what happened. If you don't know, Taylor Schabusiness was found guilty on all 3 counts today. And in a way, that's the right answer. She is guilty of 3 things. She's guilty of 2 things for sure. And 1 thing I might grudgingly agree with, but I don't agree with how the law is written. If you watched the trial earlier, you heard me talk about some of these things in the flow of the trial itself. We're going to re-hit some of those topics. I want to emphasize some points because this show ultimately today is about government. It's about our rights. It's about liberty in every story, at least the main stories that we're talking about. We're going to be hitting this theme of government overreach. There are other that we might sneak in. Oh, you're right. I didn't put the Rumble link in the video description on YouTube. Thank you. I will rectify that in a second. There are some other stories that we may sneak in. The Hunter Biden thing I didn't put in the title or description. We'll probably pay a little bit of lip service to the Hunter Biden thing. I thought it was going to be about the misrepresentation of the court. That doesn't appear to actually be the plea deal. In fact, it's about a different, not misrepresentation, but an angled slide into home. It's a little bit shiftier than the other one in a weird way and on the other party here. So we'll probably talk a little bit about that. And I'm hoping that the story about the misrepresentation of the court will further develop tomorrow. We'll see. But we'll hit on that's going to be relevant for the next little brief story. We'll hit on the Hunter Biden topic a little bit. Also, Just Pearly Things had a super cringe tweet today. And it's bad because I have relegated myself to using the language of a child and calling something super cringe, or a liberal, a child or a liberal. And both of those are things that I don't want to be. But apparently, Just Pearly Things tweeted out that a 16-year-old is more attractive than a 26-year-old. Now, this gets into interesting questions about how far the Manosphere chameleon grift needs to go before we go. I'm not on board with that. Not on board with that one. And it's pretty specific why. It actually doesn't have anything to do with the age of consent. Okay? It's tempting to just go that's a pedo statement route. I do think we maybe go too far on the pedo stuff. And I know why we do. And I agree with the sentiment. But this one merits an actual discussion about beauty, adult beauty, childhood innocence, that goes beyond just the mere slinging of the accusation. It has its roots in this idea. And do I think that Pearl actually thinks 16-year-olds are hotter than 26-year-olds? I don't know. I don't know at all what she thinks about hotness from a real perspective. I know what she will say online to grift the manosphere, but I don't know what she actually thinks. But this one does merit discussion because there is a point. 18 is not the point, but 18 is a nice, maybe modal or median reality. I don't think it's median. It might be modal. It's hard to pin down, but there is a point where a girl stops looking like a girl and starts looking like a woman. And there should be a point where a teenage boy stops looking at teenage girls because the teenage boy becomes a man and starts looking for a woman. And there is a distinct difference between a girl who is 16, a girl who looks 16, because when they say that about like a 22-year-old, there are actually features that tend to not really look that young. And a woman, there are three stages here. There's young, there's looks young, and then there's full out looks like a woman. And I contest that healthy, well-adjusted men in these days, and I understand beauty standards have not always been the same, age standards have not always been the same, but recognizing that beauty standards actually do shift societally and are not locked in the 16th century or the 21st century, I think there is a point where men in the 21st century go, that's a girl, that's a woman, women are what I'm attracted to. I think that's a real thing that happens. And if it's not happening for you because you're a hebophile or whatever, and you're attracted to 16-year-olds, I think that is something to work on and to seek help for before you become a danger to someone. Legitimately do think this. Because I remember being younger and being attracted to people around my age. And I remember aging out of that very specifically. And I think there's some point where I even aged beyond that very young looking woman too. I don't know, maybe I'm the weird one, but there's a discussion to be had about carrying the MGTOW memes into reality and making them something more. And of course, the MGTOW meme, and I'm assuming she just deleted the tweet. I haven't seen an explanatory tweet, but I'm guessing her explanation is something on, oh, it was a troll, it was a joke or whatever, playing off of her, a 25-year-old is hotter than a 35-year-old. Then she goes to 16, hotter than 26. The same spread, she's 26, which makes the spread more make sense or whatever. But I do think there is an issue with playing on this idea that beauty is affixed to a number and that a lesser number is automatically desirable. Because if there's grass on the field, go play is an old joke that is not ever to be a reality. It should not be a reality anymore. We have gone past life expectancy of 30, much to the chagrin of women who now hit the wall at 30, apparently. So anyway, we might just have a brief discussion on that. I've already talked about it about as much as I was planning to, but we'll probably revisit it a little bit later. That said, not a major theme. Those are two kind of sideshow stories to tonight. First one is Schabusiness, as I said. The second story is where we have to have some words, chat. We have to have some words. And those words are that banks are not innocently participating private entities that deserve some libertarian ideal of free market capitalism. All right? Now, I know there's this wonderful penchant to shove libertarianism in a libertarian's face when they say, hey, actually, maybe we don't want this to happen and government is the way to make this not happen. They go, but libertarians don't want laws. That's not actually true. Libertarians are not anarchists. Libertarians recognize the minimal necessity of government impact. They just want it to be minimal. And a US libertarian recognizes the empowerment to certain branches of government of certain delegated powers in the Constitution. So we're going to talk about banks and we're going to talk about payment processors because of a story I saw where Mastercard is shutting off purchases using Mastercard to cannabis stores. This is an issue. And I know what you're tempted to say. I know, because I know it. I've seen it on Twitter. I'm reading your gay little mind right now, and you're like, but it's federally illegal. Stop it. Stop it now. Stop that, you bad person. You bad thinker. We are going to talk about why this problem goes beyond mere legality. We're going to have a little exploration through the authority utilized to pass the Controlled Substances Act in the first place, because is the Controlled Substances Act constitutional? Has it been upheld as constitutional? Yes. Is it? Different story. Should it be? Maybe even a different story. Then we're going to talk about the next step. Assuming it is constitutional, we're going to talk about federal supremacy and where that limit should end, or maybe should end. Because this question had a different answer in 2005 than it does today for a lot of reasons. A lot of reasons. In 2005, if you asked me if the federal government had the power, well, hadn't gone to law school quite yet, but let's just say I had the same knowledge now that I did in 2005. Or no, same knowledge in 2005 that I do now. And you asked me, Lawyer Nick, in 2005, does the federal government have the power to make marijuana illegal even though a state makes it legal? I would have said, of course. Federal supremacy, Commerce Clause, no problem. That's an easy answer. Things got complicated under Obama because we had this weird thing where states declared marijuana usage to be legal. First, it started with medical, and then it started with recreational. And then it expanded and is now 23 states have recreational marijuana usage. And not only that, but we have now surpassed a decade of non-enforcement of federal law over a federally regulated substance, presumably regulated under the power derived from the Commerce Clause. And we start to go, wait a minute now. If a state and businesses within that state have passed laws and then proceeded to act in reliance in an increasing rate on the federal government's promise to not prosecute, do we get to say federal supremacy applies at this point, or have they waived it? And when you further consider that federal contractors are removing cannabis restrictions and testing requirements from their employment applications, we start to go, is the federal government actually exercising supremacy? Does it expire? Is there a logical point in which we go, for the federal government to turn around now and enforce marijuana law? Is that actually a fair exercise of government? Is that a reasonable thing for us to expect? Sorry, everybody, you just relied on it. You're all felons now. I don't think so. I don't think that's a reasonable example by the court. And I think that even if the court were to find that federal supremacy applies, the rollback period on the non-enforcement of federal cannabis law would probably be in the neighborhood of 5 to 10 years before they could effectively enforce it. Because courts recognize the practicality of suddenly deciding that billions of dollars of investment in buildings, in people, in inventory, in entire croplands, land, labor, that can't just be undone by the government going, nah, we changed our mind. And we have examples of why this is much more tenuous than it would have been in 2005. So we're going to explore that a little bit because I think people have these easy answers to the question. And this all relates back to the main topic of, can Mastercard tell you how your money can, whether or not your money can go from you to another person, entity, or thing? Can Mastercard do that? Should they be able to do that? And if we impose a restriction on Mastercard that says, sorry, bro, you just exchanged currency, I don't give a fuck what your policy is that an imposition on Mastercard or not? Obviously, you can infer my answer is no, that's not an imposition on Mastercard at all. That is a liberation of Mastercard. It is actually the appropriate act to do. So we're going to talk about that. And yes, I have a lot to say on the subject. So if you don't want to talk about banks because you're scared of the Jews, you won't want to listen to that segment. And then we have a lighthearted story that has nothing to do with government interference at all, where a family enterprised to bring recyclable bottles and cans from Arizona into California. And they made a little dosh on it, right? You guys, do you remember that Seinfeld episode, right? Where Kramer had this wild idea that if he packed up enough cans and bottles into a truck and drove them to a state where the recycle rate was 10 cents versus 5 cents, he can make a little profit. Of course, it turns into a nightmare because Kramer can't do anything, right? He's terrible, even though his idea is pretty sound. Well, family did that. They made a little money, and now prosecutors are charging them with felony fraud. Felony fraud for recycling across state lines, and I'm not even joking about it. It's an amazing story to me, and yet another example of insane government overreach. So that's the layout of the show tonight. All right. That's the layout of the show tonight. I hope you're looking forward to it. Briefly about yesterday, that was really annoying. Sorry, power went out right as the show was kind of getting into motion. We don't have any storms here. I don't anticipate a power outage today. So it's very rare to have the power go out. I was quite surprised that happened. Where is my Rumble window? My Rumble rants. Where are my Rumble rants? Where are they actually? Very strange. Very, very interesting. Let me redock the chat, I guess. Pop in chat. It's not even there. Okay, let me get my Rumble chat. It just it popped out, but it didn't actually ever form. So that's the main gist of tonight. Now, I don't know how super late we're gonna go tonight. 8:15 a.m. tomorrow is when Schabusiness Phase 2 kicks up. And we're going to be there for Schabusiness Phase 2. There we go. Let me talk very briefly about the week. There's a little bit of a schedule change that I was not remembering what was going on, but on Friday, I have a family event that is not here in town. Whole family, we will be at this thing, and I will not be able to do a show Friday night. And if Schabusiness goes into Friday morning, I don't know if I'm going to be able to do Schabusiness coverage. It'll kind of depend on how things go, because there's an earlier point in the day on Friday where I have to get things ready and get out of here. And I won't be able to do a Friday night show. It depends on the schedule. We'll see. But there may not be any Schabusiness or night stream. There will not be a night stream Friday. There may not be any Schabusiness Friday. If there's not a Schabusiness stream on Friday, I'll probably join Jeff or something like that. But tomorrow, we are on. It's 8:15 in the morning. There's some issues with a potential expert witness. The issues are very good ones because the defense has been awful in this case, including on their expert witnesses and the preparation of those witnesses. And I think they have a strong chance of losing this expert witness who's kind of critical to their case, even though I say they're critical. I don't think they're persuasive in any way, but they want this expert badly to make this testimony, and they're going to lose anyway. But that being said, we might have a very special new guest to the stream tomorrow, and I'm not promising because I cannot guarantee someone else's appearance. Someone I've wanted to have on a show, and particularly a trial show, and particularly in Wisconsin. This is perfect. Miss Natalie Wisco from the Kyle Rittenhouse trial may be popping in for some time with us tomorrow. And I think she will have excellent insight on Wisconsin law in this case in general. So very, very cool. Very, very cool if that is able to work out. So with that, let's get into there's a couple super chats, and then we're going to get into the Schabusiness thing. And I see the first one, AV to the seventh power. What up, girl? How you doing? Long time no see. We need to talk. AV to the seventh power says bank talk tonight. Yes, but not an industry talk so much as I'm really angry about how everyone frames the constitutionality and legality of the banking centers or the banking process, and the fact that the government empowers these banks to be a price-setting oligopoly. I hate it. I hate it. I hate it. It's garbage, and it needs to be clamped down on. But I will contend that the government is legitimately afraid of the banks. So yes, AV, I'm talking about that, and we need to talk probably about banking and stuff like that at some point, because I know that finance is in your background and you're awesome anyway. So we need to do that. Please remind me, because sometimes I forget things the moment after I say them. But yes, Ed says, regardless of laws, banks and payment processors should never be the moral arbiters of society. That is 10 trillion% true. But also, I think regulating banks in the interest specifically of promoting individual liberty is not only the correct thing to do, it is the constitutional thing to do. And that's what we're going to get to eventually on that. Aurora Uplinks says, I hear Star Wars has new writers to help Favreau. There is no help for Star Wars. Oh, and if you don't know, right after my trial coverage of Schabusiness, I went on Chris Gore's show to discuss the trial of Star Wars. They had like a 9-point accusation. They did guilty or innocent on it. And I got to go on there and talk about why Star Wars has always been trash, which is one of my favorite things to do. So that's great. Brian Watkins says, what are your thoughts on Bo Bergdahl military court-martial being vacated by a civilian federal judge? I mean, what the fuck ever, right? Who even cares? It doesn't matter. There's no, I don't know. I'm torn on these issues. I'm not aware of this particular issue or the grounds for it or the reasoning behind it. I am torn on this issue because the Uniform Code of Military Justice is not a system of justice in any way that normal civilian people understand it. The Uniform Code of Military Justice is a system of military enforcement of authoritarian rule. On the contrapoint of that, that's what you signed up for, homie. So I get it. But I'm not entirely comfortable with the UCMJ in general, and it's certainly possible that a civilian judge could exercise jurisdiction authority over a military judge if the constitutional rights, or I should say maybe certain constitutional rights of the military member are not observed. I don't know that mere membership in the military automatically negates and replaces all of your constitutional rights. Certainly some of them, might be abridged in specific ways. You don't have free speech when addressing a senior officer, for example. But I'm not sure that all of them go away. Now, on Bo Bergdahl, if the charges are still about desertion, I think there's ample evidence for desertion, but I don't know the specifics of this case. So those are my general thoughts on the matter. Specific thoughts, I'd have to look into it. That being said, let's go to this first topic, Schabusiness. Schabusiness. Okay. Taylor hashtag the Queen Schabusiness was convicted, well, found guilty today of intentional homicide in the first degree, mutilation or desecration of a corpse, and sexual assault. I have no problem with mutilation of a corpse as a charge and as a full-on conviction. I have conceptual problems with the two other charges that we need to break down, but we'll get into that in just a minute. Susan Winchell says, please toast my late daughter Gretchen, our only child. She would have been 40 Saturday. Perfect child that passed from a massive stroke 3 weeks after turning 35. Damn. I got you, Susan. I got you. Okay. And I know she went, or I know the jury came back really quickly from deliberations, and people were like, are you getting back on? I had made a commitment that I would go on Chris Gore's show, and then I had dinner with my family after that. So wasn't really able to do it, but there wasn't much to cover. I mean, the guilty verdict reading took something like 10 minutes, but real quick, here we go. To Gretchen, the only child of Susan, taken from this earth way too soon, from an unexpected, unpredictable tragedy, illness, sudden death. May she rest in peace. May she be free from pain. May she bask in the joy of her parents' love and appreciation. Share with them in their sorrow at her passing. And may she wait for them to meet up again in the afterlife. Cheers. Very sorry to hear that, Susan. Prayers to you and your family as you relive the very uncomfortable anniversary of the loss of a child. Okay. So here we go. Let's get some things out of the way. There are some issues I had in this trial. A couple I can identify very specifically. Let me talk about them conceptually and then specifically, because those are two different things. The first one is a matter of searches. Now, this became an issue yesterday at the close of trial. The state elicited testimony from one of the expert witnesses who reviewed data taken off of Taylor Schabusiness's phone and found searches for Jeffrey Dahmer, a flaming pentagram, the Satanic Bible, and they introduced these as evidence against Taylor Schabusiness, mentioning them before the jury. Now, the defense objected to the mentioning of these things before the jury and asked to argue the issue. These should be excluded, they say. Now, this should never have been in front of the jury at all, in my opinion. This should have been taken care of in pretrial motions. But alas, I don't know why it wasn't. My sense on this is that this defense attorney has been bad on a lot of these things and has dropped the ball on several things, including the pretrial stuff. And we'll find another instance of this in a little bit. And he's similarly bad at arguing about stuff he's asking to suppress at trial. Now, the state argued that all of these things would be relevant to the intent to murder this guy. All right. So, first degree intentional homicide in Wisconsin requires that not only did they kill someone, but they had to, like in every first degree murder state, they had to manifest a cognizable intent. Now, it doesn't have to be like an hour, a day, a week before, doesn't require meticulous planning. It just requires an intent to kill someone. That's what it requires. Now, there's a second part of the instruction that everyone thinks I'm omitting. I'm not, but I'll mention it here for posterity. You can infer the intent to kill as a juror from the idea that someone knows the continuation of an act will cause death and continues anyway. You can infer that. Doesn't mean you do infer that, but you can infer that if you find the other circumstances to be appropriate to make that inference. So you have to want to kill someone to do this. The state introduces evidence as evidence specific to the intent to kill. I do not think searches in your Google bar about Jeffrey Dahmer show any intent to kill in any way. Jeffrey Dahmer is a ubiquitously infamous serial killer to the point that Netflix made a highly successful series about him that ran last year. Now, that series did run after the crime, although it was announced prior to the crime, but I'm not going to, I initially had speculated maybe based on the timing, because I couldn't remember when the series ran, that it's possible she was searching related to the series. I will say that she probably was not. But I do not think mere searches for Jeffrey Dahmer, Jeff Boyardee, that's a meme, by the way, Jeffrey Dahmer walking into court looking all sexy, Jeffrey Dahmer butt, I don't think that shows an intent to kill. I think that shows an infatuation with a dark celebrity. And that may be unhealthy and it may be cringy, but I'm not sure it goes in any way towards intent. And I think this is a highly prejudicial thing to associate one of the most infamous serial killers in American history with a person accused of killing and dismembering someone, implying that they intended to do it because they searched for this thing. Do I think it's possible that a search for Jeffrey Dahmer could be evidence of intent? Yes. I think the state should have to show why it's evidence of intent to make it relevant. And there was no offer of any sort of link between that other than, well, she did it. And I know people disagree with me on this, but I'm going to hold true. I think that's an inappropriate use of a very prejudicial thing. Now, addressing that, here's the next step. Judges, do I think this is appealable? Well, of course, anything is appealable, but do I think it will have reasonable success? No, not at all, actually. I don't think that that is an appeal point that will win, and here's why. Judges at the district court level have broad discretion as they are the hearers of evidence, and they are determining this evidence live from the credibility of the witness, the credibility of the person. They're making determinations based on arguments being presented by counsel, and they get broad deference to make those decisions. If every evidentiary decision was subject to an automatic appeal just because a lawyer disagreed, we'd never get anything done. The standard used in reviewing an appealable evidentiary issue is, it's twofold. One, is it an abuse of discretion by the judge? And then two, does it sufficiently prejudice the defendant? Or is it what they call harmless error? In this case, my initial reason was this is really bad. But then prosecutors didn't make much of it. It received only a passing comment in closing argument. So first of all, I don't think the judge abused their discretion. I just disagree with the decision. Second of all, there's almost no prejudice that can be inferred from this of any appreciable amount. I don't think the jury's entire perception of Schabusiness's first-degree murder charge hinged on those Dahmer pictures. If it did, we might have a different story. So ultimately, I'm annoyed about it, but it's nitpicky. That frustrated me, but nitpicky. The next part is less nitpicky, more frustrating, but more incumbent upon the defense than on the court or the state. And that is that the defense subpoenaed a witness. Now, this witness, the defense seemed to think was important. And here's why I can infer the defense found this witness important. The subpoenas issued by the defense were as follows: to this witness and to all the cops that testified on behalf of the state. They sent those subpoenas out to just make sure that those people would be on the witness list in case the state didn't want to call them. Once the state called them, they canceled all those subpoenas. So there's one witness that is testifying on behalf of the defense, sort of being called by the defense because the state didn't want to call him. Now, here's my issue. The state was able to interview and get a statement from this person because they arrested him. The defense issued the subpoena. The defense sent an investigator to try and get a statement from this person, was never able to connect. After that, the defense took the subpoena, requested the state, which is typically done by a law enforcement officer, serve the subpoena upon the defendant. The state was able to make contact and not the defendant, the witness. The state was able to make contact and serve the subpoena on the witness, even though the investigator for the defense was not. So the defense never gets to talk to this witness. They don't get a statement. They don't get a deposition. They don't have anything from this witness at all other than the statement elicited by the police when this witness is arrested as a possible connection to the criminal act that Schabusiness was ultimately charged for. The defense keeps trying to exercise the subpoena, and they're told by the state that the state has made contact with a family member of the witness, and the family member says the witness has a health issue that will last weeks and they will not be able to make it to the trial. And no one at all has any information as to what the health issue is, where they are, why they're unable to attend. Now, the defense counsel asked for a mistrial here. Wrong move, in my opinion. You're not going to win on a mistrial motion for that. The defense does not ever seem to ask for enforcement of the subpoena. Judge, issue a warrant. Issue a warrant, bring them before the court, or force an offer of proof out of some motherfucker as to why this guy is not obeying a subpoena. Like, the judge is like, okay, well, there's different medical reasons why someone can't attend. You know, a cold, like a bad cold, is one medical reason. But, you know, maybe like a major surgery or something is a different kind of medical reason. You could say a bad cold, well, we got to delay it a day. He has to stay the trial or move on to some other thing and bring the witness in the next day, or you delay it till next week. Whatever you have to do, ask for it. The defense doesn't. But the whole thing fucking stinks. And now, I don't think this witness would have changed the outcome. But here's the thing. The defense's theory, as we put together from other testimony and ultimately the shitty closing argument that came out of the defense attorney, was that Taylor Schabusiness did not commit the crime that she told the cops that she did, but in fact, she wasn't there, and it was this guy because it was his car. Now, look, I know that that is absolutely fucking batshit stupid. It is the dumbest tactic they could have taken. That's a throwaway argument in the alternative to any better argument, including the guy did it to himself, including cutting his own head and penis off after he was already dead. That would have been a better argument. But that doesn't matter because you have a constitutional right to call people for your defense, and that right is constitutionally guaranteed, meaning it is enforceable by government, and it wasn't done. Now, I have a big problem with the defense because it's on the defense to make the demand of the court to enforce that subpoena. But I also have a little bit of a problem with the state seemingly colluding in the evasion of the subpoena and the judge not going, well, should we issue a warrant? The judge not suggesting maybe we could get a reason why they're unavailable. Instead, the defense just cucked, capitulated, and said, we'll agree to stipulated facts from the statement. Terrible. Bad representation. Is it ineffective assistance of counsel? No. It was a tactical decision. I disagree with it. It's bad, but it's not ineffective assistance of counsel. Those are the two major areas where I think constitutional issues arose in this court. But otherwise, I found the court to be relatively fair. I didn't agree with all the judges' evidentiary decisions, but I didn't find any of them other than maybe the Dahmer one to even approach a level of egregiousness. So that being said, I just wanted to lay that out as my overall thoughts on the process, the constitutionality, the fairness of the trial from the perspective of the government. The prosecutors outside of the Dahmer search stuff, I really thought acted pretty professionally. They weren't too scummy. Now, the prosecutor who gave the closing argument was a piece of garbage, but not because he was scummy, but because he was annoying. His manner of speaking was really lame. He had gay affectations all over the place. Right. He said right 1,000 times, and it made me want to die at the hands of Schabusiness. But that's just stylistic. That's not egregious misconduct in any way. Certainly, these prosecutors acted in a better way than the Rittenhouse prosecution did. But it goes to this certain truth about prosecution. The better case they have, the more clean the case they run. The worse case they have, the dirtier they play. Now let's get into these conceptual issues with charging after a couple super chats. Mostly Gluten says Jeffrey Dahmer is a local legend in Wisconsin who wouldn't have him in a search history. Yeah, I don't know. It does not seem that weird to search Jeffrey Dahmer to me. And I don't even search for Jeffrey Dahmer. Well, except today when they said Jeffrey Dahmer's sexy butt, I was like, well, I have to check that out. I have to see what that means. And I did the search and I didn't find any pictures of Jeffrey Dahmer's butt. So that was weird. Well, except for one of Evan Peters, the actor playing Jeffrey Dahmer. But that's it. I didn't find any actual Jeffrey Dahmer butt pics. Pisses me off a little bit that was all like a lie. Like, well, at least make the search worth it. But they didn't. So, but yeah, it's not weird to search for Jeffrey Dahmer, in my opinion. It is weird to search for Jeffrey Dahmer's butt. That's strange, but not indicative of murder. And maybe if she went and raped Jeffrey Dahmer or Evan Peters while he was in Jeffrey Dahmer cosplay or something, maybe, but I don't think so. Okay, Nexus says, 1, aliens are real, if you believe the government, I guess. 2, grays are controlled telepathically like a doll. 3, we have the spacecraft. It's a 5D object. 4, the alien bodies. 5, defense contractors working with Milk Skunk Works to reverse engineer. Yeah, there was some weird UFO testimony in Congress. Look, if the government's going to come out and say that aliens are real and yeah, we have all this stuff, then I'm inherently disbelieving them. So we'll see. And then finally, Wolfgang Deo says, so this one Japanese Russian gal who's super attractive, I sent her gibberish in Russian and she was being a bimbo. So in Japanese, I asked, can you not think it's probably easy, and blocked her, just being Rasputin. Okay. All right. Well, I mean, there you go. I don't know what other facts you need in that case. That's open and shut. Okay. So back to, now that I've talked about the procedure of the case, the outcome of the case. Oh, so one other facet of this case is very strange. The trial continues tomorrow morning at 8:15, even though a verdict was rendered by the jury today in the charges. But this trial is being done in 2 phases. And the reason for this, I surmise, is because of her plea, which her plea is not guilty by reason of insanity or mental defect or disability. This is different from competent to stand trial. This is basically if they're found guilty as a reasonable or competent person, the jury is then asked to consider a follow-up question of, are they fucking crazy though? So more evidence will be brought in, pretty much, I think, exclusive to experts who will testify about her mental state at the time of the killing, whether or not her insanity precludes her ability to manifest the requisite criminal intent to be guilty of a crime. She is almost guaranteed to lose on this one. She has one bipolar diagnosis from one of the multiple mental health professionals who have examined her. And they're trying to get an expert on drug use to come in and say that repeated long-term methamphetamine use can lead to brain damage. She's not been diagnosed with said brain damage, but that's the testimony they're resting basically the entire case on, is that her bipolar disorder plus her use of methamphetamine, trazodone at the same time, and the potential brain damage from methamphetamine use is sufficient to overcome her intent. I don't think they're going to win, especially because they never successfully argued anything about her intent at all. One of the biggest failings of the case, in my opinion. So phase 2 will start tomorrow. Hopefully it'll end tomorrow. It won't be a big thing. It does not require a ton of long testimony, but it's experts, and experts are annoying to examine and cross-examine because they go on forever. So that's that. That's the next part of the trial. Okay. Let me get to my 2 problems with the charges. First, murder in the first degree, as stated, requires the intent to kill. I think there was plenty of evidence that supports the idea that Taylor Schabusiness did not actually intend to kill Shad Thoyer. Thoyer, whatever his fucking name is. Shad. I do not believe she intended to kill him, and I believe that sufficient evidence is in the record to say that you cannot prove beyond a reasonable doubt that she manifested the intent. The intent to kill comes from statements that she made in the police interview while she was allegedly under trazodone and meth and not advised by counsel at her own choosing. She made statements such as, "Have you ever loved something so much you wanted to kill it?" And another statement of the officer asking her if she continued strangling him, didn't she know he would die? And she said, yes, eventually. Which, by the way, does not mean that she intended that death to occur. And I want to be very clear on that. Because if you think in your mind that after 10 minutes someone might die, but you're only 5 minutes in, you may be wrong, but did you intend for that to kill them? Not really. Not based on that statement. In addition to that, she has contraindicative statements stating, I never intended him to die. In the same interview, I never intended him to die. I did not want him to die. This was a consensual act, and even though he started to change color, he started to cough up blood, she stated that he looked up at her and said, keep going. Now, you may suggest that she was lying at those 3 points, but not anywhere else in her entire interview. And that's certainly possible. But I have a really tough time saying we should believe everything she says except these specific points, which happen to be in her favor. Now, why do I think that this is important and goes towards actually the defendant's side on intent? Firstly, remember that the state bears the burden to prove beyond all reasonable doubt that she manifested this intent. They have to prove the intent element to the beyond a reasonable doubt standard. So if you have roughly equal statements from the witness or from the defendant as your sole evidence of intent, and they go the opposite direction on both those statements, you have to weigh the credibility of the defendant making the testimony, and then you have to find on the balance of burdens which one wins. The state has to show a 95% likelihood on their burden. The defense just has to rebut over about 5%. Reasonable doubt. Is it reasonable to entertain doubt about her intent to kill this guy? And I think the evidence says yes. Further, in closing argument, when talking about the intent element, the state says she told us her exact state of mind. You don't have to look into her mind, just listen to her words. Okay, we take the state at their word and say we listen to her statements and believe them. She's a whammon. We listen and believe. That's what the state set as the standard. If you do that, you come to a neutral argument from a credible witness, according to the state, or credible defendant, according to the state, that says she said both, she intended and didn't intend to, which means there is reasonable doubt to say she did not actually intend to kill that. That's a wonderful approach to the intent on murder one. Big problem. Defense attorney is a retard and did not make any arguments about her intent at all. Nothing. He doesn't mention any of that. He doesn't point to the statements. He doesn't counter the state's assertions. He doesn't point out that the state leaves out her statements that counter indicate their argument. He never says a thing. It was one of the worst closings that could have been delivered by anyone at all. Absolutely ridiculous. Terrible, terrible defense. Again, his defense strategy was to say that she was loopy during the interview, and even though she gave exact specific details about how she committed this crime, including the location of a dildo hidden in a box, the location of every body part, the location of the cuts she made, the identifying the limbs that were severed and denying severing other limbs. She gave exact details of the crime. His thing was, well, she didn't know where she was and was just confused and gave these statements, so that's reasonable doubt. An absolute fucking batshit insane strategy. But it was at least a strategy, so it's competent assistance of counsel, apparently. That's the problem with murder one. Now, let's briefly get to the sexual assault charge, because I have a big problem with this one too. Not that it matters. First-degree intentional homicide carries a mandatory sentence of life in prison without the possibility of parole. She's gone. She's done. Here is the sexual assault. Now, according to all of the testimony, there was no sexual contact prior to the death of Shad. None. The only testified sexual contact was that she used a dildo to penetrate the mouth and anus of Shad post-mortem, and she put his pee-pee in her mouth after he was dead and maybe jerked him off a little bit. Now, the statute says that sexual assault that they are charged under is when, without the consent of the person, someone penetrates the anus, the vagina, or the mouth with a penis. Or technically the genitalia. So I guess if you take a sounding rod and shove it into his urethra, that would also be sexual assault under this. That's the definition. And there is a subheading that says it does not matter if the victim is alive or dead. This is a very weird charge. It is very strange. First of all, I do not believe that the state proved that there was not consent. While there was no testimony about any sexual contact under the statute prior to his death, there was testimony from Taylor Schabusiness that they were about to engage in actual sexual activity, in penetrative activity. It was leading to that when asked. The asphyxiation was part of the sexual foreplay, so to speak. It was a sexual act that he consented to. I don't see beyond a reasonable doubt that he did not consent to sexual activity. So the question is, when you die, are you unable to consent, or maybe more appropriately, is consent revoked? And I think, even though I know this is a gross and weird discussion, it merits exploration. Let me be clear on this. I do not have any problem with the state saying it is illegal for you to fuck a corpse, bro. Not a problem. I think fucking a corpse is gross, weird. People who do it maybe belong in a grist mill. Go away. Don't need you in my society. I don't want you fucking the dead. But let's face the reality. That's just meat that is rotting in real time. That's not a person. That will not be a person, cannot be a person. That's not a thing. There is no consent because there can't be consent, because that is the same as fucking a tree. Trees can't consent. Are they raped? I don't think so. I don't want people raping trees, but I don't really care if trees get raped. Because the issue at this point is it's not a sexual assault. The purpose of assaultive, sexual assaultive, battery crimes, any of these things are the enduring damage and traumas suffered by a victim. If you ain't waking up, you're not suffering trauma. And I have a real problem with that. Now, what if during the rape they die? Well, that's a different thing. That's a felony murder. We recognize that the sexual assault that produces death becomes a felony murder. So it's a completely different question. But if you're raping someone and they die, are you subsequently raping them again because their consent that they didn't give you ended? No, you're charged with the sexual assault of the living person and then the murder that follows. You're not recharged with the subsequent sexual assault because it doesn't make sense to charge sexual assault on a dead thing. It's just meat that happens to have holes. What the fuck are we doing? Why is this a law? Make it illegal to have sex with the dead all day. That makes sense. There is no victim. There's nothing. The victim, I guess, is society, but that's not what sexual assault is about. Sexual assault is about preventing damage to a specific victim who will be particularly damaged by a particular act. So I have a real conceptual problem with this one. And I will say that though the statute says it doesn't matter if the person is alive or dead, I do not think that, one, I don't think that that's constitutional. I think that's weird. But two, in this particular case, I do not think, and the defense didn't argue this, and I don't think a jury's prepared to actually entertain the argument, but I think she had consent. So then we go to the question, do you lose consent when someone dies? Which goes back to a question we've been wrestling with as a society since the Brock Turner thing publicly. Do you lose consent when someone is unconscious or intoxicated? If you don't remember the Brock Turner case, this is a Stanford swimmer who is alleged to have engaged in sexual activity with a girl who, quote unquote, could not consent because she was too intoxicated. Now, interestingly, he was also too intoxicated, and apparently, I mean, I guess that didn't matter, but she was too intoxicated and or she passed out during the act and he lost consent according to somebody. But if someone consents to sexual activity and they do lose consciousness, and you don't notice, and you continue, is that rape? Is that sufficient for a criminal rape? Should it be? I don't know. And the answer isn't clear in Wisconsin law. It says in the sexual assault statute, penetration of these areas when you do not have consent. And it says specifically that if you're asleep or unconscious, you cannot give consent. Doesn't say that the dead can't give consent. And it doesn't say anywhere that sleeping, unconsciousness, or death loses consent. This is a very strange law. I have a problem with applying sexual assault. Again, necrophilia, illegal all fucking day. all day. No problem with that one. But how do you actually sexually assault a corpse when the necessary element of assault is damage to a victim that will experience damage? And I would have liked to see some argument on it, because here's why. Did they win on that argument? I don't think so. But did they appeal that issue and maybe get the law clarified and changed? Possibly. Probably for the better. So I have a problem with those two charges. Flat out. I do not like them. Do I think the jury made the wrong decision? No. Defense attorney didn't argue any of this. He did not attack a single element of a single one of the crimes alleged. She wasn't going to get away from the mutilation of a corpse. Briefly addressing that. Mutilation or desecration of a corpse has a required element that they could have tried to attack, but not very effectively. And that statute requires the intent to cover up a criminal act through the mutilation. I killed someone. I chopped them up to hide the body. That's trying to cover up the killing, right? The murder. Someone said, well, wait, if she wasn't guilty of the intentional murder, is she automatically not guilty of the other one because she couldn't intend to cover up a crime she didn't commit? I say no. And I say no specifically in this case as well. I'll say not necessarily generally and no specifically. And here's why. They elicited statements from her that indicated an intent to cover up what had happened. Very specifically, she kills him. She didn't mean to, but she's now faced with a dead body that she doesn't want to explain. So she resorts to chopping him up in an effort to transport him out of the house without anyone knowing. In her meth brain, that was the thing she was trying to do. She is literally admitting to the intent to cover up a crime. Now, just because she didn't commit a crime does not mean she didn't intend to cover up a crime that she thought she committed. She thought she was in the wrong after the fact. And even if she didn't intend to kill him, this is another thing. I want to get to that intentional homicide point one more time because I forgot to mention the most important part. Even if she didn't intend to kill him, it's almost guaranteed she committed some crime. And she was still trying to cover that up. Now, back to that intentional homicide, and we're almost done with this case. And then I'll stop talking about it completely, and we'll move on. We'll move on to the banks. I do think she is guilty of homicide. I think she is guilty of reckless homicide, which is recklessly causing the death of another with utter disregard for human life. I do not think she wanted to kill Shad. I do think she engaged in an activity that was very likely to produce death, and she persisted in that activity without any regard to whether he lived or died. That's a different standard. It's very important, and I think that was the appropriate charge, and I think that is constitutionally what she should be convicted of, because the important distinction is life without parole, which is what she's going to be sentenced to, or life with the possibility of parole after something like 60 years. Up to 60 years, I think. It's like 20 to 60 years. And then a possibility of parole at some point. I think that's the more appropriate punishment for the crime. I think that criminal act fits the description of what happened. That's my soapbox. Take it, leave it. I don't give a shit. That's what it is. That's my opinion. So, obviously that's not going to happen. These are all conceptual. These are all opinions. And my opinion does not matter at all because I'm just a commentator on the internet. But I think talking about these legal principles is very, very important. And somebody out there may be on a jury at some point and go, maybe I should think very specifically about how the law is worded and what evidence was actually presented, and if I agree with it. Now, the state didn't make any case for a lesser included offense. I don't know if that was something that they did not consent to or whatever. I'm not an expert on Wisconsin criminal process in regards to lesser included offenses. It should have been a lesser included offense. Her attorney should have still argued for that, because the argument for her being unable or not manifesting the intent to commit the homicide goes along with not only reckless homicide, but also it goes along with the insanity defense that they're going for. And in the absence of winning on insanity, which she won't, it would still be better to have her have a possibility of parole in her interests. Of course, that's the framing we're looking at, is what is her interest here as a defendant. So that's my soapbox on the issue. Very passionate about the constitutionality of criminal law and its enforcement. Okay. Let me read super chats, and then we will move over to Rumble. Bad Vibe says, Nick, God decided you needed to do the ultimate obsidian face, huh? I guess. Dylan Scott, Schabusiness has a Mortal Kombat fatality. Brutality. Patrick O'Brien says, there's one way to judge if Pearl's zeets went too far. What would her comments look like if she went farther? Nick, ideas? What would her comments look like if she went farther? Oh, you're saying if she said a 6-year-old is more attractive than a 16-year-old? Is that how we're doing that? I'm not sure. And I'm not going to impute that statement on her, personally. I think the way to determine if it went too far was, did she delete it, and why? If she's going to stand by the statement, why delete it? Not an FBI says Pearl's favorite movie is Little Woman. Oh, come on. It's Happening with Harper says, I don't know what to think about this murder. No history shown of violence or evil. Drugs don't make one do this. Psychotic break, dismemberment can't be easy. No, and that's one of the things people are saying, meth makes you do crazy things. I don't know. A lot of people do meth and don't murder people, and especially not in this horrific, gruesome way. Typically, it's a reduction of inhibitions associated with most substances. Now, I know there's some that drive you into a weird psychosis. Sure, it can happen. I don't know enough about meth to make that determination, but I know that there's not an absurd rash of meth-related killings, but maybe there is a decent amount. Maybe there's an argument to be made that it does. I don't know. Not an expert on that one. Heather Iris, thank you for the donation. Hugh Jassel says, I was that super attractive Japanese Russian girl. Good job, Hugh. Proud of you. Dumb username says, new season of Baki is out. He fights a caveman. Oh, awesome. God, I love Baki. I love it. Okay. I'm drinking a Monster. It's just a tall one. All right. Here we go. Okay. So this is, I believe the last one of these, because I think the offer is ending really, really soon. But the sponsor for today's show, I'm going to mention one more time. It's a sponsor I've mentioned for the past couple shows, cbdistillery.com. cbdistillery.com, promo code Rumble. Look, if you've watched the past couple nights, you know the spiel. This is a company that sells THC products, Delta-9 THC products, and CBD products where they are legal. They ship them to your door. They get you the product. They have all sorts of different uses. They have relaxation, relief, sleep, recovery listed right here on the website. They use specifically formulated plant-based solutions, different mixes of CBD and or THC to produce different results. I've not tried every one of their products. I don't know if they all work. I know that people all around the world get tons of relief from CBD and THC. The products I have tried seem to be just fine. One was a tincture you put under your tongue. Tastes like ass. You know why? Because it's a marijuana-based product. They don't taste great. But What's it do? Provide a level of calm, a level of like chill pain relief. It's not like a Tylenol. It's just an all-around sort of comfort thing through the day without slowing you down. Tried the night gummies. Those things were very effective on me. Made me extremely tired, made me want to go to bed. Not a lot of things make me actually want to be tired at night. Now, I am tired at night, but I have narcolepsy. My brain's fucking broken. It doesn't do the thing where you go, "Oh, yeah, I'm so tired." When I lay down, go to sleep right away. Fantastic. That's narcolepsy for you. But it's convincing my brain that I need to lay down. That's the hard part. These things, excellent at it. If you have trouble sleeping, maybe it's a way to help out. You just got to try it. If you're going to try it, now's the time. cbdistillery.com, promo code Rumble will allegedly get you half off of your order. Thank you to cbdistillery.com. This is apparently a limited time offer. So take advantage of it. Give it a shot. Maybe it'll help out with whatever issue that you have. Maybe Schabusiness should have been given some CBD. Well, Shad probably. After he died, just shove some CBD in his mouth and his butt. Maybe it'll perk him right up. cbdistillery.com. All right. Oh, shit. Ted Goddamn Cruz says, is there a possible argument for felony murder if a person kills someone while under the influence of an illicit substance such as meth? Interestingly, probably not. Because it's typically not illegal to be high. And I know that's weird. It's typically illegal to possess a substance. It's typically illegal to sell or acquire a substance. But absent a specific statute, and I don't think most states have them, it's not illegal to be high. Now, the high is often used as a justification for a search for possession. But it's kind of weird, right? I'm not sure that Wisconsin has a statute prohibiting intoxication with a substance. Wisconsin law, influence, controlled substance, maybe? Driving law. Operating under the influence. Yeah, it's typically just drugged driving. And I know that's weird for people because it is fucking weird, right? Like I can't have heroin, but I can be on heroin. And that's most states, by the way, maybe all of the states. Now, if you kill someone while under the influence of a substance, I mean, you still have the potential for a murder charge or a manslaughter charge. That doesn't change. But the substance use is not typically a felony. And so then you don't have a felony murder. So very weird, but them's the breaks. Okay, so with that, guys, we are going to go over to Rumble. I would love it if you would join me. According to Rumble, right now, there is one viewer over there. Just one. I think their counter is broken, but I don't know. Just says one. Look, Rumble, is there only one of you there right now? Put a 1 in the chat on Rumble if there's only one of you. So very weird. Very weird on the numbers there. I think it's a glitch somewhere, maybe on my end. But there we go. Oh shit, I need to edit the chat's going wild. I'm gonna add the Rumble link to it's up at the pin chat. So full show on Rumble. Adding it to YouTube right now, because I forgot to do that earlier. There it is. Go ahead and pop over to the Rumble stream. Join us over there for the rest of the discussion. We're going to talk about the banks. Let's see if the Merchant Hit Squad comes to town. I'll see you guys over there. Remember, no show Friday night, and maybe no Schabusiness stream on Friday if it's still going. Otherwise, Schabusiness tomorrow, 8:15 a.m., both YouTube and Rumble. And then there will be a night stream, presumably tomorrow, absent some unforeseen instance. Catch you next time. You cunt!
For the thousands in attendance and the millions watching around the world, ladies and gentlemen,